Ensuring a supply chain in line with the German Due Diligence Act. Background: Germany implemented the German Supply Chain Due Diligence Act, known as LKSG, in early 2023, which looks at ensuring better social and working conditions for workers and regulating the environmental liability of businesses. A complaint has already been filed against Amazon, IKEA and Tom Tailor for failing to conduct security checks on the company's suppliers, which is a breach of corporate due diligence under the law. Amazon and IKEA are not even German-headquartered companies, but only have significant German operations to exceed the applicability threshold. Hence, this indicates the applicability of LKSG to be more global than it might seem. Impact on outsourcing: LKSG aims to provide protection for workers in foreign countries, where suppliers in those countries may find it difficult to meet the compliance demands of German customers. Further, the complexity and cost of audits in emerging markets may lead German companies to rethink their outsourcing strategy and move production to their nearest country, where compliance may be relatively easier to ensure. However, reducing dependency completely from outsourcing countries might not be possible because they might still have to depend on indirect suppliers from such countries for the supply of certain components. Hence, there is no option to escape from the ambit of the LKSG. Monitoring the supply chain: since there is no other option but to adhere to the LKSG, corporations should look to invest in ethical sourcing and work together with their suppliers to achieve those objectives. To achieve this, an organization should observe some basic elements. Element of discrimination: organizations should investigate whether there is any difference in pay for workers of different classes/genders for equivalent work. Separate arrangements for eating or recreational activities may indicate discrimination based on caste/religion. They should check whether there is any scope for arbitrary termination of employment due to non-permanent nature of employment contract. How the female employee is treated during pregnancy should also be monitored. Element of forced labor: the presence of a large number of contract workers can be a sign of exploitation. Absence of a formal grievance and redressal mechanism in the organization may suggest a work environment with unacceptable working conditions. Lack of payment records and management structures increases the risk of forced labor. Persistent signs of injury/illness among workers at the supplier facility may indicate forced labor. Element of human trafficking: if the workforce is composed of a large number of vulnerable groups, this may indicate a presence of human trafficking. If the recruitment process involves the stipulation of a large fee to be paid by the worker for the job offer, this may indicate the existence of human trafficking. Temporary and unsafe accommodation is often a symptom of migrant labor, which increases their chances of being trafficked. High security measures at the supplier's facility and/or residence may indicate the existence of human rights abuses. Element of child labor: the presence of large numbers of young workers increases the likelihood that children could be part of the workforce. Paying lower wages to a certain segment of the workforce may mean that those segments of the workforce are not adults. When child labor is involved, there should be a discrepancy between the records submitted to the regulatory authority and the records maintained by the supplier. Element of poor health and safety measures: the frequent occurrence of accidents indicates a poor safety philosophy. Accidents could also be grossly underreported. Using substandard safety equipment is an indication that health and safety is not a high priority issue for management. The number of health problems reported by workers can indicate whether they have been exposed to hazardous work conditions. Ways to reduce this risk: organizations should conduct appropriate investigations to find out the elements that pose a risk. They can increase site visit frequency as well. They should introduce effective whistleblowing procedures. It may be useful to ensure that supply contracts contain adequate contractual safeguards. Determining risk-prone areas and taking necessary measures in consultation with legal counsel can help reduce risk. Any questions? Ask C-Quel.